May it please the court, honorable judges, esteemed opposing counsel, and distinguished members of the court, good afternoon. Before you is Team V168, and we have the pleasure to represent the plaintiff in this case. I will use 20 minutes, and preserving 3 minutes for rebuttals, and the rest minutes will be used
Representations?
We are representing the plaintiff.
Names?
B168.
Yeah, we just know the names of the council.
Okay. My name is Flora.
For the defendants, appearance, please.
May I please the court? May I please the court? Honorable judges, I'm Counsel Robert Sylvester, leading counsel for the defendants. I'm with my co-counsel, Counsel Anna Oscar Change, with the lead of the court. May I invite her to bar?
Thank you very much. Counsel for the plaintiff. This court advocates you one more time for your presentations of the case. And that time will also include your rebuttal submissions or rejoinder. And this also goes to the defendant side. It's 1 hour time, which includes your rebuttal submissions as well. Much as you have taken your appearances in the quorum, we will now invite you, counsel, to commence your case. Welcome.
Honorable judges, before going any further, I would like to give a brief highlight on the key facts of the case.
Counsel, excuse me, just 1 minute. Take your sitting judge. The panel is composed of 5 judges, and the chief judge is Peter who's talking now, and the other concerning judges are Mr. Judge Karua Michael, Honorable Judge Nixon Philip, Honorable Judge Philipson Maboko, and the then Honorable Judge Kidwembe. This is a panel which will decide over this matter. So I wanted to make it very clear that you should be able to know the presiding judges when addressing your case. So, Counsel Flora Cousins, you may now proceed to present your case.
May it please the court, honorable judges, before going any further, I would like to give a brief highlights of the key facts of the case, and afterwards I will address to the key issues that are framed in this case, and responsibilities by its parent company to act as the carbon trading implementer. Consideration of the key facts, I will address the first and the third issues respectively, and my co-counsel will address on the second, fourth, and fifth issues respectively. Honorable judges, in respect of the first issue, it is our firm submission that the plaintiff has locus standi to institute this case. Locus standi is a right to bring a legal action to court, but also from the case of Yunashubi Balozi versus trustees of Chama cha Mapinduzi, the court stated that a person needed to show before the court that his rights or interests have been interfered with, and so he may be able to bring an action before the court. but also the smallest of the interests are immaterial. So having said so, the following are the grounds that I'm going to...
First in the citations of the case, you should be able to cite the full citations and the court which decided that case. And from which country? That case of Lujuna Shubarat.
And I consult my... Honorable Judge, the case that I'm citing is Lujuna Shuli Balozi versus the Registered Trustees of Chama cha Mapinduzi, 1996, TLR 203, and it is a High Court case. Having said that, I will establish the grounds that made our client to have locus standi. The first ground is that our client case and okay. In the case of Salomon versus Salomon, honorable judges, the court established that a company is a separate legal entity and it can sue or be sued in its own name. But also, if referred to Section 4 of the Interpretations of Laws Act, Chapter 1, Revised Edition of 2019 of the Legal Republic, it recognizes companies as legal persons. So, honorable judges, referring to the case file at hand.
Counsel, before you file the case, don't we have the relevant provisions within our Companies Act of this country which provide the same position as the company, as the legal personality and Italian mandate to sue or to be sued under the Companies Act? Do you have any provision that support that position?
Yes, we have the relevant provision. If it may please you, can I go and get that?
Proceed. Consider your materials.
Honorable judges, if referred to Section 3 of the Companies Act, Chapter 212, Revised Edition of 2002, Section 3 provides the mode of an incorporated company. So this establishes that upon the meaning of incorporation actually to create that separate entity that gives it a legal personality separate from its owners or its members. Honorable judges, the fact that the plaintiff is a subsidiary company that was incorporated under the laws of the Legal Republic, it is a legal person to institute this case. And so, this was clearly stated in the paragraph 12 of page 4 that showed that the plaintiff was a subsidiary company incorporated under the local laws of the Legal Republic. Honorable judges, going to the second ground, our client has interests arising in these suits. Honorable judges, the restriction clause according to the law.
So, before you proceed, so the mere fact that it is a subsidiary company, does it give it the status, the locus to institute a case before this court? By just the fact that it is a subsidiary company?
Yes.
Why?
Because when we say it is a subsidiary company, it means it is a separate legal entity from its parent company, meaning that...
No, we have no concern with it being a separate legal entity. The concern is it being a separate subsidiary. Does it give it a locus to institute a case before this court?
It gives a locus because it creates the legal personality that gives a legal person a right to institute a case before.
What gives the party a locus? Where do you get a locus to institute it? What gives you that right?
The right that
From what you are reading from the tribunal decision, what is the locus? And does being a subsidiary company gives what the tribunal is saying? In that case, you are citing.
Yes, Honorable Judge, because from the case of Yuna Balozi, it says that a person should have rights or interests. So being a subsidiary company, you're given a right of being a legal person before the law, and so you can institute a suit before the courts.
So that alone, you being a subsidiary, because you're a subsidiary, because you are having, what is a subsidiary company in the first place?
A subsidiary company is a legal entity that is created from a parent company.
What makes it a subsidiary?
Pardon?
What makes a company a subsidiary of another company?
Honorable Judge, thank you for that question. A subsidiary company is created when the parent company has majority shares to the subsidiary company, meaning that the subsidiary company has shareholders that provide majority shares to the parent company, and so it becomes a subsidiary company of the same parent holding company.
Yeah, you can just assist if you have some materials to it's allowed to bring some materials to assist. Proceed with the counsel.
Much obliged, Honorable Judge. So our client has interest arising in this suit. Honorable Judges, the restriction clause, according to the law, must be very clear and precise, and it should not have any defects. I will specifically address to the assignment of rights and obligations which our client derives the interest from. So, Honorable Judges, if we refer to the case of Oliver Hatcher versus Shane Park Association, which is a common law case. It is cited as Oliver Hatcher Construction and Development Incorporation versus Shane Park Associates, number 2755000, 2008. It's a common law case. It states that the mistake of failing to include magic words, and by magic words we mean the words like void or invalid, that denote voidness or invalidity, preserves the power to assign. As I said earlier, in the common law case, our law of contract is silent on that, so we're going to rely on the case law.
Sorry, our law of contract act is silent with what?
Our law of contract act is silent on the restrictiveness of the assignment clauses that I'm about to stipulate.
Yeah, yes, basically, our interest is you should be able to address this court, whether there's any exceptions that confer right to a client to maintain a suit before this court. Because before this court, you have a dispute between your client and the defendant. But your client was not a party to the contract, which is now put before this court. So you should be able to address this court on what exceptions are available, which confer your client right to bring the suit, even if it was not a party to the contract. These are the issues we are interested to hear from you.
Thank you, Honorable Judge. If we refer to the Memorandum of Understanding, specifically page 14, at the preamble, the definition of the parties, if we go to the second last line, which defines the proponent, it expresses that the proponent, which expression shall, where the context so admits, include its nominees and assignees. So as to my case, our client is an assignee, and so he is party to that contract.
Okay. A follow-up question would be, if you take this court to read the interpretations of the word opponent or the principle in this case, what is your comment if you read that definitions and read together with clause 7 of the integral party of the contract, then explore from that? If you still maintain your position that so long as the international company has been defined to include assignees, and how do you connect the company with the client and assignee in the presence of clause 7 of the integral part of the MOU? Did you understand? No, please.
Thank you, Honorable Judge. Clause 7 addresses that there shall not be transfer and assignment unless there is written consent from the parties. But this clause is not restrictive on the consequences that will happen if this written consent if no written consent of the parties will take place. And this is because there is no any invalidity or voidness that is shown.
So you agree with the draft of the MOU that for the assignment to be valid, there must be proof of written consent?
Yes, I agree.
And where there is no proof to that effect, then it can be said that there was no valid assignments of rights to your client.
When there is no proof to that issue, it means that there is still preservation of the power to assign, because the parties to the contract, the preamble, which states the definition of the parties to the contract, it defines assignees, meaning that the Memorandum of Understanding has included assignees and it has consented to the assignment.
Okay, Council. So you want to tell this court that the definitions under the preamble defeats the integral party of the contract. And if I may ask you, if the preamble is in conflict with the integral part of the contract, which part should prevail over the other?
If it may please you, can I consult me?
Proceed.
Honorable Judges, in reference to Section 25 of the Interpretations of Laws Act, Chapter 1 of Revised Edition 2019, the preamble is part of the Memorandum of Understanding. And having said that, there is a contradiction that is seen here between the preamble and the clause 7 on transferability and assignment of rights. So, in case of on contradiction, it means that we are going to apply the contra-preferendum rule that says that we're going to apply the contra-preferendum rule that upon contradiction, the provision that will be rendered effective will be applied to the party that is going to apply against it.
Counsel, just to take you back to your reference to the preamble. The preamble defines that a proponent may be an assignee, but that does not in fact assign anyone any rights under this agreement. Are there any facts or is there any evidence that tells us that there is assignment there's in fact assignment in this case.
Thank you, Honorable Judge. If we refer to page 4 of the case file, specifically from the second last line, it says that Ecoforest Limigwa Limited agreed to take all and any rights and liability of Ecoforest International Limited in those projects, meaning that the transfer assignment was done here in terms of the rights and responsibilities that are going to be acquired in the project that is going to be implemented before the Memorandum. So having said that, Honorable Judges, I conclude that my client has interests, and so it has a local standard to institute this case. The third ground on local standing, Honorable Judges, is that our client has local standing in the realm of environmental litigation as per Section 202 of the Environmental Management Act, which gives a local standing to any person for the interests of the environment. And back to the fact in hand, there are various calamities that were shown that were spotted actually by the president of Limigwa, specifically the MootCourt landslide in 2019 at page 3, which shows that there was a requirement of an instant or an immediate environmental action that should be taken. And so our client is defending the environment in terms of environmental litigation.
Just to understand better, what is again the environmental calamity in this scenario that happened?
Thank you, Honorable Judge. If you refer to page 3 of the case file, the calamity that happened is Ambalia flood in 2018 and MootCourt landslide in 2019.
By that time was the contract enforced?
It was not enforced.
So then?
The contract was not enforced, but it was one of the factors that led to the implementation of the carbon trading project in Zimbabwe Republic.
So, does that give the local standard today for something that happened before there was any legal relationship?
Thank you, Honorable Judge. Can I consult my colleagues? Thank you, Honorable Judge. If I can also refer to the actions of the villagers to cut trees and burn charcoal, the actions of overgrazing in the river valleys areas, it shows a huge impact on environmental degradation.
So you want to convince this court that if you go to the forest, you take firewood, if you go to fish, you destroy the environment. Is that what you're saying? And that is a natural calamity to have firewood.
Thank you, Honorable Judge. The continuous and persistent actions of doing the same actions, it can lead to such calamities.
Okay, so finally, can you give us statistics from the facts that we have which indicate that we are calamities because of people taking firewood? Give us a specific provision of that shows. If there is not, then you can admit that there is not, and then we proceed.
Honorable Judge, there is no any facts that shows the statistics.
So, fairly speaking, you lied to the bench?
Honorable Judge, I'm not lying to the bench. I'm just trying to connect the events that were leading to environmental litigation.
But in this case, those events did not exist.
The event existed, as I said in page 3, that were actually stated by the President. And that thing is done after a research that has been conducted previously. And so this is like a report that is provided after a continuous research.
Fair enough, but as far as what you're arguing before us is concerned, we've already admitted there was no calamity that just, at least from the facts that we have, that justifies the action. You've already admitted that. Just, you should understand that being honest is one of the virtues of being a lawyer. So you've already admitted it. It's okay. You can proceed. It's not a weakness to admit that you lied.
Thank you, Honorable Judge.
Before you proceed, so you're saying that that particular, the last ground you're trying to explain gives locus when it is an environmental litigation. So before us, is this an environmental litigation or a dispute in regards to the breach of the MOU that you have signed with the... So what justification are you giving us based on the last ground that you're using to justify your locus before this court?
Thank you, Honorable Judge. Can I consult my co-counsel? If it pleases you, Honorable Judge, can I invite my co-counsel to explain this?
Sure, please.
The court, I'll address specifically on the issue that Mr. has posed. Honorable judges, among the impacts of this suit will safeguard the interest of the civil republic environment. So regarding Section 2 of the Environmental Management Act, it allows a person to bring a suit which is going to sustain the suitability of environmental preservation.
So before you proceed much, I'm saying, so before us is the environmental litigations and not the breach of the MOU.
Suit. It also includes the best interest that our client has on the environment of the civil republic.
So if we say that, because before us we do not have the environmental litigation, therefore that ground you're using doesn't stand, we will be correct.
May you please pardon?
I'm saying, so if we say that before us we do not have the environmental case that is filed before this court, and the ground you're using to justify your locus doesn't stand, will be correct.
Honorable Judge, respecting that question, is that all the grounds will stand because apart from the interest that we have from the contract, we also have the interest to preserve the environment, and consequently the actions of persistence will outcome what already happened in 2011,
So
2019.
I think you just have to understand my questions. I'm talking about the last ground.
Yes.
This is an environmental litigation. Now, my concern is that this is, before us, we do not have an environmental litigation, but rather a breach of the MOU. So if we say the ground you're using to justify your locus doesn't stand, will be correct.
Honorable Judge, respectfully submitting on the same question, I stand in my position that apart, because once you read section 202 is that if there is interest to preserve the environment, apart from the interest that arises from the memorandum of understandings of assignments, we have the interest to preserve the environment.
Let me simplify your work, okay? So that you've closed this matter and go to the second issue. Which case did you file in this court?
Honorable Judge, it's a civil case, a commercial case arising from the...
So you filed in this court a commercial case,
Yes.
not an environmental case. Just to be candid, don't worry, just to be candid. You filed a commercial case.
Honorable Judge, responding to that question is that among the interest that we want from this case...
No problem about the interest, we understand that part. But you filed a commercial case.
Yes.
Is that correct?
Yes.
All right, just like that.
I'm very guided, Your Honor. May I invite my co-counsel to proceed on the third issue. Thank you.
I proceed with the third issue at hand. Honorable judges, it is our firm submission that the registration fee that was imposed 18% VAT is not a taxable supply. In pursuant to Section 3 of the value-added tax, VAT can only be imposed on taxable supplies or taxable imports. And the definition of a taxable supply as per section 2 of the VAT is that if any supply that is made in mainland illegal.
Council, we'd like for you to elaborate to the bench that what was imposed VAT in this particular case. Educate us on the facts.
Thank you, Honorable Judge. Honorable Judges, if we refer to page 7, paragraph 21, it states that afterwards, EcoForest International Limited submitted the project concept note together with the proof of payment of registration fees, which the CPMA charged 1% of the expected certified emission reduction CER together with 18% VAT, meaning that the ZCPMA imposed VAT on the registration fee.
Thank you, Council.
Thank you, Honorable Judge. Having said that, I would like to conclude this issue that the registration fee is not a taxable supply, and so it's not liable to pay VAT under the scope of the value-added tax.
Why are you saying it is not a taxable supply?
It is not a taxable supply because a registration fee is just a mere charge of as an exchange of an administrative function that was done by a government authority.
What is a taxable supply?
A taxable supply is a supply that is made in furtherance or in the course of an economic activity carried out by that person.
So if you read that particular section 3, it tells you a taxable supply can be a supply of goods or a supply of services. So what did the village council supply?
The village council supplied a service of registration process, which is just a procedure for an incorporation of the company.
So in your perspective, the registration, is it a service?
It is a service.
So if it's a service, and the taxable supply does include also the supply of the service, that means it can fall under the ambit of the VAT, and therefore it could be subject to VAT.
Honorable Judge, in the definition of a taxable supply, we're talking about an economic activity, but the service that is provided by the government is a non-commercial activity, and so it does not fall as a commercial activity that will involve a taxable supply in this case.
Why are you saying it is not an economic activity?
It is not an economic activity because it's just a mere procedure that was done.
No, now you're confused, because don't use, if you say we have already agreed it's a service. So even if you use it's a procedure, it doesn't change that it is a service. So name it the manner, whatever you want to name it, but it is still a service. The question is, why should it not be an economic activity? What gives a service a status of it being an economic activity? Because you are justifying it should not be imposed because it is not an economic activity. So your task is to justify to us that this is not by mere words, by using the justification from them.
Thank you, Honorable Judge. If we refer to section 2 of the value-added tax, it defines section 2 of the value-added tax. It defines an economic activity as an activity carried on to involve a supply of goods, services, or immovable property. So having said so, the supply involved here will be a taxable supply, and for our case, the registration fee is not a taxable supply.
One last question. Just to follow up to the question that I've asked you. What exempts a service that you are saying that it is not an economic activity, that it should be subject to VAT, because you just say it is not an economic activity and therefore it should not be taxed. Why is it not? Why should it be? Should it not be taxed? So we need justification from the laws. You have the VAT Act with you.
Thank you, Honorable Judge. If you can rephrase the question in a simple language.
I'm saying, you said your justification based on the explanation you have given, that the services of registration that was rendered by the village council was not an economic activity, correct? And therefore it should not be subject to VAT, correct? So what is your legal justification to that?
Thank you, Honorable.
Now you understood my question.
Yes. According to how I've understood the question, I still stand to my position that the fact that it is an uncommercial activity does not suffice an economic activity.
I have no doubt with your position. You only need a legal justifications to your position that you stand on it.
Thank you, Honorable Judge. If it may please you, can I reserve this question? Having said that, I conclude my submission and welcome my co-counsel to proceed with the second.
Oh, sorry, we reserve it until who will be able to answer the questions and at what time?
Thank you, Honorable Judge. My co-counsel will address that issue at the end.
I need to please the court. Honorable judges, I'll join in by acknowledging the arguments raised by my co-counsel and I'll address the court based on the second, fourth, and the fifth issue. Honorable Judge, based on the second issue, it is our submission that the Memorandum of Understanding is enforceable under the laws of the Zimbabwe Republic. Honorable. Honorable Judges, it's our ordered submission that the Memorandum of Understanding is enforceable under the laws of the Zimbabwe Republic. Taking guidance to the case of Global Hardware Limited versus Tanzania District Limited, as the High Court was guided by the decisions of the Court of Appeal in the case of MS Wananchi Engineering and Construction Corporation Limited and Mr. Silvano Petti, the Court of Appeal was in a position that the enforceability of a Memorandum of Understanding does not rely on its title rather than the certainty of the terms and conditions stipulated inside there.
Yeah, so you should be able now to read us the intentions from the MOU in question. So we should go to what provisions and intentions that the parties intended to create regulation.
I'm guided, Your Honor, referring to clause 15 of the Memorandum of Understanding, it clearly stipulates that in case of any dispute, it will be submitted to a court of competent jurisdiction. And this concludes that when any dispute arises, it attracts legal consequences, making it that the parties were intended to create legal relation and to be bound by the terms of the Memorandum of Understanding. And this position is to be provided in the case of Msagali Company Limited versus Barclays Bank of Tanzania Limited. Honorable judges, I have responded and
Yes, interesting. Is it all the time that when the parties incorporate dispute resolutions clause in their agreements, that's the only criteria that the parties intended to create a relationship binding or enforceable? So if that clause was not included, do you think there was no any provision that will at least suffice to the discourse that indeed the parties intended to create a regulation?
Honorable judges, to respond to that ground, I'll provide that the general rule when it comes to intentions to create legal relation is that every commercial or any business transaction intends to create legal relation. That's the general rule, and it was adjudicated in the case of the Hawa Mohammed versus the Aisha Mohammed. Honorable judges, apart
You were referring which case were you referring?
the Hasha Mohammed versus the Hawa Mohammed versus the Aisha Mohammed.
Of which year and which country?
Honorable Judge, the case is from High Court of Tanzania, and it is the court will submit the copies of the
It's
case.
reported case.
Yeah, it is reported, it's found online.
The principle underscored.
The principle underscored is the principle of intention to create legal relation, that when it comes to any economic activity, it attracts legal consequences. But when it comes to social relations, it it does not attract legal relations. So conclusively that our client was entering into this was all from a business transaction. Consequently, it creates the intention of the party to be bound in legal terms. Honorable judges, having submitted the issue to the fifth issue, the second issue, I'll proceed respectively to the fourth issue framed by this honorable court, and it is our order contention that our client did uphold the principle of permanent sovereignty over natural resources. Honorable judges, referring to the preamble of the Natural Wealth and Resources Permanent Sovereignty Act of 2017, the law, in definition, does to understand what rights does the principle of permanent sovereignty confers to a state in order for us to be who can access those resources. Honorable judges, referring to Article 8, Sub-Article 1 of the Constitution, the state derives sovereignty act on behalf of its people. But also, moving to subsection 4 of the same section 5, the law provides that the state individual village council, referring to section 147 of the local government authorities, referring to section 147 of the Local Government District Authorities Act, the individual village council is given all executive power when it comes to decisions of the development project.
Yes, Council. How can I address this confidently that the right exclusively granted to the foreign country, the foreign company, did not infringe the sovereignty of the country? And remember, these rights were granted to a foreign company. How can you say that there was no infringement of the sovereignty of that particular state?
I'm much guided on that question, Your Honor. I was respectfully submitting on my first ground that our client consulted relevant state authorities which provided go-ahead to access those resources. Referring to the facts in hand, from the outset of the project, our client did consult the Zimigwa Carbon Trading Management Authority, and it discloses its intention to invest. Also, our client.
Okay, sorry that. If you read the intention of the drafters, or if you read the spirit of the Wealth and Natural Resources Act that were found in Section 4 and the other provisions, who had the ultimate authority as per the spirit of the law, especially the preamble? Who had the ultimate authority of the natural resources between the people of the state and the government?
Honorable Judge, respectfully submitting on that question, it is provided in Article 8 of the Constitution, Sub-Article 1, that the state derives authority from the people. So if a state is a sovereign state, it means that it has the power to represent its people, and that means that it is legitimately. Referring to the landmark case of SMZ Machano, it clearly stipulated that if a state is a legitimate state, it means that it is acting legitimately on behalf of its people. But also, responding to the same question, the state can act on behalf of its people when pertaining natural resources when the state has secured equitable benefits of the people. That gives the right.
No, my interest is very confined on the ultimate authority in the spirit of the law, particularly Section 4 of the Act, between the government and the people in terms of the sovereignty, permanent sovereignty to the natural resources. Who has such mandate? And I'll invite you to read Section 4 particularly, and the preamble to the Act to appreciate between the two, the government and the people when it comes to the sovereignty to their natural resources.
Honorable Judge, can I pick up my copy of the law?
Yes.
Thank you. Respectfully reading Section 4 of the law, it says that the people of the United Republic shall have permanent sovereignty over all natural wealth and resources, but subject to subsection 5, because the law has to be read as follows. As when you relate subsection 4 to subsection 5, which says that subsection 5 to subsection 2 specifically, it says the natural wealth and resources shall be held in trust, okay, excuse me, Honorable Judge, subsection 3. The purpose of subsection 1 and 2, all activities and undertakings related to the exploration of natural wealth and resources shall be conducted by the government on behalf of the people of the United Republic. Means that the United Republic is a sovereign state, evidenced by the general elections conducted, that the government in hand acts legitimately on behalf of its people, having right to regulate access.
Yes, I can understand you, but the concept that I was bringing to attention was on the sovereignty of the natural resources. Because when we find section 4.3 of the Act, the government comes into play when the government wants to execute the functions under the law. But the ultimate authority is provided in section 4 sub 1. And there is no exclusion clause in section sub 3 which provides subject to subsection 1, if you can get it.
I clearly get your question and respectfully submitting that. So, if the government has the right when it comes to allocation of those resources, if the government has the right and our client consulted the government, does it mean that our client obtained lawful access? That means that our client will obtain lawful access.
Counsel, I would like to stop you right there. You're saying that by virtue of your consultation with the government, your access is lawful. However, our brief of the case file shows us that there were allegations of bribery and other inappropriate and unlawful actions.
I'm respectfully submitting that question, Honorable Judge. All allegations came from political affiliations of the opposition, and there is no way that our client did not comply with the law. It shows that...
Where in the case file are you directing as counsel?
Honorable Judge, referring to the case file, Honorable Judge, in referring to paragraph 29, it shows the opposition leader who came out to claim that our project was colonial. Our client is a new foreign colonizer, and relevant to what our client was doing, he was not a colonizer. This means that those are just political affiliations from the opposition party. Honorable Judge, having said so, my client also ensured that the people of the Legal Republic did obtain equitable benefits.
Before you proceed, due diligence in terms of the legal regime that is existing in that particular state, right? So, reading through the law you were citing, the natural wealth and permanent resources and permanence already determined. So, we invite you to read section 6.
Section
6.
Okay, thank you. Yes, okay.
Just read it.
Pursuant to paragraph C and I of the Article 9 of the Constitution, it shall be unlawful to make any arrangement or agreements for the destruction of exploitation, acquisition, and use of natural wealth and resources except where the interests of the people are fully secured.
So you see the paramount consideration. Just read it, bro.
In the wake of the violence, villagers were injured, livestock were killed, and families were torn apart, scattered in despair, no alternative land or housing or spoken to the victim.
So what you're reading and what is stated in the law, then what is your assertion?
Honorable Judge, responding respectfully to that question is that there is no any place that our client evicted the villagers, but also addressing on the interest of the people, our client, those were the actions of the first defendant.
Thank you for an amazing, fantastic response, if that can be said. So, from the last question from the judge, it seems you already understood that these illegal actions were taking place, but you admit these were really not your obligation, but rather it was the government. Is that correct? If you go to the memorandum because you've already admitted. If you go to the memorandum, I want you to look at clause Roman 11, and this is clause 5. Clause 5, clause 1, and then Roman 11, which says it's your duty to report any illegal activities in the project site that the proponent becomes aware of during the operation of this memorandum of understanding. So from your own response, you admit these sort of illegal or violative activities were going on and you didn't report them. So this makes you complicity in whatever that was happening. Do you admit that?
Honorable Judge, I do not admit that position because when it comes to reporting only illegal activities, Honorable Judge, our client had to do capacity building, and this was at the implementation of the project. Honorable Judge, the project was violated, was even frustrated before it was implemented, and it gave us no room to conduct any capacity building, report any illegal activities. It all happened in frustration, and our client was not in that position as even it's right, we were chased away by the president. Honorable Judges, that is my situation.
Counsel,
Yeah.
before 5.26 of the Memorandum of Understanding, where in this agreement that we understand you signed with the Village Council, you made sure that it was the Village Council's responsibility.
Our client ensured that the villagers, 1 out of 4 of the project area was left to the villagers. That the villagers, our client ensured that there is an alternative that would have been given to the villagers. This meant that...
Can you direct us to the facts?
Thank you. To occupy the Bocamoso game reserve was valid according to the law. With respect, was not complied with. So the minister acted firstly in access of power because in reference to section 4 of the Village Land Act, it allows only the president. But also, honorable judges, when we refer to the model of transferring, it means that the villagers must be consulted and paid. So respectfully submitting that the area was falling under the jurisdiction of the... So referring to the facts in hand.
Okay, so you want to tell this court that the decision was made by the Village Council? The decisions was made by the Village Council?
To do what? Judge?
As we are trying to improve this court that the decisions in respect of the Bocamoso reserve, was it made by the Village Council and not the Village Assembly?
Honorable Judge, the decision that I was talking about is the decision of the minister who acted in excess of power, but without following the procedures that were provided by the laws of Zimigwa. Honorable Judge, referring to the case of Dalamia, Atarato Taiwatu, and others, as the Honorable Minister of Natural Resources and Tourism, in general, the court was in a position that once an administrative body acts on excess of power, it means that the decision that has been reached is void of remission. So this means that the decision made by the minister was not valid.
Okay, Council. Did you take any action to challenge the decisions of the minister before you come to this court? And do you know how the decision of the minister is challenging in law?
Honorable Judge, respectfully submitting to that question, we didn't go to challenge the decision of the minister because our client believed that the area was under jurisdiction of the Village Council, hence this suit.
So, if the decision of the minister has not been challenged and has not been rendered illegal, don't you think that the decisions of the minister remains intact and valid in absence of it not being quashed by the court of competent jurisdiction?
Honorable Judge, respectfully submitting to that question, because we are adjudicating this case, we will make up the procedures of filing a judicial review to challenge the decision imposed by the minister. So
So if you have the case, then at this juncture you have no right to question the decision of the minister at this stage, much as it has never been challenged by any judicial process.
Honorable Judge, at this stage, we submit that the grant of Okamoso Game Reserve was valid, and the area falls under the jurisdiction of the Intimizwa Village Council. That is our position in this case. But also, concluding to the same issue, who has the right to the carbon project revenues, we have to submit that regulation. It is the one to be entitled, and it has the right, much obliged. I pray before this honorable court that our client to be found to have locus standi to institute this case, but also the memorandum of understanding is enforceable under the laws of civil, the principle of permanent sovereignty, and grant of rights to the Okamoso Game Reserve is valid.
Do you have any general prayer in respect of the suit?
Honorable Judge, I make this court of office.
So that was with the cost.
I mean that.
On the plaintiff side, now it's a turn to defense counsel to present their defense in respect of the issues which have been discussed by the plaintiff side. You're welcome.
Met with the court, True and Slee, and also will be making prayers for the defendant. In case of time, I will be using 30 minutes, and my co-counsel will use 15 minutes, and I will reserve 10 minutes for Salibato, although we didn't hear about reservation of rebattles from the plaintiff. By the wisdom of court, particularly rebattles, we are happy to reserve time for Salibatos. Okay. Honorable judges, we also adapt our memorials to form part of this oral submission. Honorable judges, listening to the arguments raised by the plaintiff in this particular case reminded me during the discussion in the passing of the Act No. 5 and Act No. 6 of the Zimbabwean Republic, which are the Permanent Waste-Oriented of Natural Resources Act and the renegotiation of Unconscionable Terms Act. Specifically, the introductory words from Professor Paramagamba Kabut when he was submitting why there was an importance to come with this act. Honorable judges, reference is made to this particular critical moment in the Parliament of Zimbabwe because third world countries, most of the third world countries like Zimbabwe, have been subject into a long period of domination since the advent of unequal exchange, since colonialism, and the current, the neo-colonialism, where their resources have been plundered and used for the benefit of other countries and not the people of the Zimbabwean Republic. Honorable judges, in this case, we will revolve about the issue of carbon project management, which was entered between the Ecoforest International Limited with the Zimbabwe Village Council, with the Intimizwa Village Council. We will also show that it's very important, although it's very important to consider the issue of sustainable development and the issue of environment, it is also important to consider critical issues and considerations that in our submission we will show that the plaintiff has not considered those particular principles. We will show in our argument that the plaintiff doesn't have locus standi to bring the matter before this honorable court. We will show that the memorandum of understanding entered between the natural resources, also the right of the local communities from Intimizwa localities, and to ensure that people are getting benefit from the resources. With that concerning that has been originated from the memorandum of understanding and not Ecoforest Zimbabwe Limited. It is our humble submission that the plaintiff doesn't have locus standi due to the following reasons. The doctrine of privity to contract, the strict parties who are not part of that particular contract to enforce the agreement that has been put in that particular contract. This has been cited in a number of cases, including the case of Dunlop Pharmaceutical Tire Company Limited, which had Selfridge. The case of 19 of whether Dunlop would have bring an action before the court for the service of tire which was being made by Selfridge. And the court was of the view that although Dunlop was a beneficiary to that contract, he didn't have the authority to bring the matter before the court because he was not a part to contract. It's a humble submission that reading through paragraph 1 of that particular contract, of particular memorandum of understanding, it's a humble submission that the plaintiff doesn't form part of the doctrine of privilege to contract restricts the plaintiff from disputing a case before this honorable court.
Counsel, I have a question for you. You're saying privity of contracts should be the reason why there is no locus standi, correct? You did charge taxes to this transaction, correct?
Yes.
From a party that was not part of the contract.
The tax was charged to the proponent of that particular.
Proponent. So yeah. Proponents meaning.
Proponent of the project who was given recommendation to implement the project.
So they were given the rights to implement the project.
Yes.
But they don't have the locus standi to institute the suit.
Yes, definitely.
Yes, Councillor Roberts, you are taking this bench into the doctrine of privity to contract, right?
Yes.
Do you accept that the doctrine of privity to contract admits certain exceptions? So, do you accept that it admits certain exceptions?
Yes, it does admit.
It does not admit.
It does admit certain things.
Okay. So we will be interested to see from your submissions the exceptions which are available and which do not fit the plaintiff's case.
Okay. Thanks, Chief Judge. May I consult to get case for submission on that particular issue? Honorable Chief Judge, the exceptions to the doctrine of privilege to contract have been given in the case of Ultimate Security Limited versus Maxwell Insurance Tanzania Limited, which is a case from the High Court of Zimbabwe Republic. In this particular case, they cited the case of Fraser River Pipe versus Dreadnought Limited, which in this particular case, they developed two exceptions. The first one was the intention of parties to extend the benefit to the said party, and the other one, the activities done by that said party, which have been given that authority, were following within the scope of that particular argument. Connecting this with the case at hand, although the parties had intended under Article 7 of the Memorandum of Understanding to assign, they have considered that that particular assignment or whatever rights that have been enumerated to the plaintiff was not justifiable.
Counsel, I follow the argument and I think I can understand it. Maybe just a little clarification. Does the assignment need to be expressed or it can also be implied?
Yeah, assignment.
I'm asking so, taking into account that from the facts that we have, Zingwa Limited, Ecoforest Zingwa Limited, participated fully in the negotiations, participated in paying taxes, participated in talking with the village council, participated in the execution of the proposal and of the memorandum of understanding. So I want to understand, from what you're arguing, it is as if you are suggesting the assignment should be expressed. But from the facts that we have, it seems the assignment was implied due to the involvement of Zimigwa, Ecoforest Zimigwa Limited. How do you explain that?
Thanks, Honorable Judge. I appreciate that the assignment can be expressed or impliedly assigned. However, looking through the facts of this case, especially on the dispute resolution clause, resolution 15.1.2, it's clearly shown that the parties to this particular case were the ones who were supposed to bring the case before this honorable court. And also, I can relate this with the principle of subsidiary company. That this being a subsidiary company, it has no rights to bring an action against the parent company which entered into a memorandum of understanding.
So before we go to the subsidiary and parent company, so you basically agree with this bench that an assignment can be expressed or can be implied. And you agree, slowly, that in this case these facts exist, only that you dispute that the subsidiary company in this context had no jurisdiction because it was not mentioned in the dispute resolution clause. Is that correct?
Yes. That's what we are submitting, that this particular fact, the plaintiff...
No, you've already said this. So the follow-up question, which is the last question on my part, is in order to bring a case before a court of law, how many ways are possible? Do you need to have a contract? Or, according to the jurisprudence, for example, of a jurisdiction, if your interests are affected, is that a valid locus standi to bring a case?
Okay, based to that issue, the principle is different. It depends with particular cases, especially for the cases that are of constitutional nature. Any person who is affected can bring those actions before the court. But for the cases that emanates from the contract agreement, only parties to the contract are the one who can bring an action. And this is well stipulated under the rules of this court, High Court of Division rules, which provide that in dispute of commercial issues can be brought before this particular case. Okay, thanks. Honorable Judge. The plaintiff relied on the issue of doctrine or the issue of subsidiary company and signing the case of Solomon versus Solomon. And the shareholders of that particular company are not, though they are the one though they are the party to the company, they acquire a different legal personality. Taking into account that Ecoforest International Limited was registered under paragraph 12 of the material facts. This showed that it had acquired its own personal legal personality, and then it cannot bring an action against the parent company which has a different legal personality.
Counsel, can you elaborate to the court? Can you elaborate to the court why? Because if I direct you to paragraph 12 of the facts, it states that I'll share it for you. To comply with all local laws, local procedures for setting up a company under the laws of Tanzania, a subsidiary was opened. So, and as we understand from the regulations regarding carbon trading, that an investor or a proponent is required to have a local company. Is that correct, Counsel?
Yes.
Now, today we have a local company who is operating a project, and you are telling us that because they were not included in the initial contract agreed with the parent, that while you have recognized throughout the facts, you have recognized their execution of the project, but today, when it is time for them to claim their right, you ask this court to not recognize their interest? Is that what you're telling the court, Counsel?
Honorable Judge, our argument is this contract was entered between two companies, between two parties. And under this particular contract, and leading through clause 7, it put a mechanism for an assignment whenever any party wants to assign rights and rights under this particular project. So if at all the Ecoforest International Limited wanted to assign, it would have resorted to Article 7 of the Memorandum of Understanding. Also, another thing to note is that whatever kind of assignment was given to plaintiff under paragraph 12 of the material fact doesn't apply, doesn't supersede the clause in the Memorandum of Understanding, which was signed later. If they wanted to give assignment, they could have specifically that alleged Ecoforest Zimigwa Limited has been incorporated and given that assignment status.
Yes, Council. Your counterpart has submitted the case. They have drawn our attention to the definitions of the parties. And if you go to the definition of the parties, the Eco International Forest Limited includes its assignees. In this case, the plaintiff is one of the assignees to the parent company. What is your response in respect to their submissions that, and they say further that the entire contract should be construed altogether? And if this court retired to oppose the judgment, it should consider all particulars, the entire particulars within the contract, and construe them together. What's the response in respect to their submissions on that?
Yes, much obliged, Honorable Chief Judge. Our submission in respect to that, whenever there is a conflict between the article of the memorandum of understanding and the title of that particular memorandum of understanding, then the article of that particular memorandum of understanding supersedes, because the article is the binding those particular articles supersede because they have the binding nature of the introductory or preamble.
Yes, you're interested. Which particular law are you filing that position?
Okay, Honorable Chief Judge, allow me to give this question for my co-counsel to make a research, then we'll get back to it.
The particular position?
Yes, yes. Okay, Honorable Judges, the particular position also can be drawn from the Vienna Convention on the Law of Treaties, which provide for the interpretation of treaties, especially when there are those issues of challenging or conflicting, like the particular provision.
Counsel, I was pleased to wait for your fellow counsel because if you are taking us to the Vienna Conventions, then we will ask you this before this court treated. It's just in this use.
Okay, I wait for my co-counsel. Okay, allow me to submit on issue number 4 before waiting for the issue number 2 from my co-counsel that I can give a prayer on the issue number 2. Regarding to the issue of exclusive right of power and sovereignty of our natural resources, it's our humble submission that grant was in violation of the principle of permanent sovereignty of our natural resources. First, the principle of permanent sovereignty of our natural resources has been given by the United Nations Declaration on the Principle of Permanent Sovereignty of our Natural Resources, Resolution number 1803 of 1962, which under Article 2.1 of this declaration, it shows that the government has the permanent sovereignty of our natural resources to use, to freely dispose their natural resources. This has also been embedded in the Zimbabwean Constitution under Article 8 and Article 9 and Article 27 of the Constitution, which provide that the government of the Zimbabwean Republic has the authority to permanent sovereignty of our natural resources. The key emphasis under this principle is that the resources should be used to benefit the people. And this can be evidenced from Act number 5 of 2017, the Natural Wealth and Permanent Sovereignty of Natural Resources Act, specifically under Article 4 and under Section 4, which provides for the principle and for the interest of the people. Looking through this particular grant, through this particular grant of exclusive right, it gave unlimited power to the Ecoforest International Limited, which is contrary to Section 4 of the Act number 5 of 2017.
Counsel, I have a concern. You are representing MootCourt, correct?
Yes, yes.
And you're saying that the grant is in violation of the laws.
Yes.
So you're going against yourself.
I'm not going against our argument. Our submission is the grant of exclusive right, the grant of exclusive right was not in considering the principle of permanent sovereignty over natural resources.
What the judge is asking, it is the government you represent that granted exclusive right. Is that correct?
It was the first defendant.
Which, according to the local laws of the Republic,
Yes.
is part of the government.
Yes.
So then you are admitting it is the government that violated the laws relating to permanent sovereignty of natural resources.
The critical issue here is not about whether that the government violated or not.
What is the issue?
The issue is whether that particular grant violated the principle of permanent sovereignty.
Okay, who grants it?
The grant was made by the Municipal Village Council.
So who violated it?
Honorable Judge, leading through this
Just be specific. Because, look, you're supposed to assist the bench to come to a better conclusion. So you're saying the issue is who granted. Okay, so we've established that it was granted by the village council. Village council is part of the government, if we understand according to the local law.
First defendant, that was an oversight, and it was an intention.
There was an oversight violation by one part of the government, which was not supposed to be the case. In that sense,
I would like to say that this particular exploitation, this particular grant was done with the
government or not.
It is.
All right. Then, so we have closed the matter. Then, in that sense, I mean, there's no reason.
The exclusive right was in violation of the principle of permanent sovereignty over natural resources. That's why the president and the trustee of the people resources, and at every time the government had the right to,
It's part of the government, not part of the
the
government.
part of the government.
Okay. So, so if she's part, right, according to the Constitution, is that correct?
The part of the executive arm and article.
Council, you're drawing this matter very far. You've already admitted.
Yes.
So the government
Capacity and the president and the trustee
to rectify the violation done by the government.
to promote the principle of permanent sovereignty over natural. This court finds that the grant of exclusive right to Ecoforest International Limited did violate the. It is our humble submission that the grant of Bokamoso exclusive right was invalid. The owner of that particular project, and who was the owner of this Bokamoso Forest Reserve? Bokamoso Forest Reserve was declared to be a reserve under paragraph 18 of the material fact, and the declaration was done by the minister. And the one with authority to deal with the general land, with reserved land, is the managing out is the one with responsibility to deal with the reserved land is the Singapore Wildlife Management Authority. Therefore, under section 8 of the Wildlife Management Act, whatever grant that was done by the Municipal Village Council to Ecoforest International Limited over the area which was not falling under their jurisdiction, that particular grant was invalid. And therefore, we ask for this honorable court to declare that particular grant of exclusive right of Bokamoso Forest Reserve was invalid.
Council, your argument is quite entertaining, but I think it follows sort of the same logic of fate that I want us to explore further. So in this issue, you also admit there was a violation because the authority that granted exclusive rights in this case had no authority to do that. But if I understand, according to the Vienna Convention on the Law of Treaties, you cannot use internal laws to defeat international obligations, if I understand it better. So if this is an international company that enters into a contract with sort of a government branch, then it is not its obligation to make sure that you follow your own internal laws. Why do you place this responsibility on a plaintiff that is not a government? What is the basis of doing that in law?
As investor, they had a duty to make a due diligence, and when they consulted the Zimingwa Wildlife Management Authority, they were told that particular area has multiple jurisdiction, that there are other parties who have that particular right. And they were told that there was an area that was covered by Jolibanzi land, and there was an area that was under the Bakomaso Forest Reserve. Therefore, it is the failure due diligence of the plaintiff which led them to engage or to enter into an agreement with the area that was not in the jurisdiction of their authority, which gave them that particular land.
Yeah, Council, I have some very few questions. One, who is the chief advisor of the government? So the second defendant, who is the chief advisor of the government? The particular authority, and the second is did not take
18 on whether when the minister was making a declaration, the consultation were made. And
was exercising power under the GM in terms of paragraph 19 of the facts.
Yes, the minister declared that particular area to be legal.
So you agree with me that the GM is a subsidiary administration of the law of this country?
Yes, I do agree.
And you agree with me that the same GM is still intact and it has not been quashed by any court of competent jurisdiction?
Yes.
Do you know that if a person acts or if a person acts through the law, his actions deemed to be lawful? Because the minister was acting through the GM, which is the subsidiary administrations. So why do you want to defeat his power at this stage while he was exercising his power through the valid law which has never been cautioned by any court?
We are not questioning the authority of the minister. We are confirming that since that particular land was declared by the minister, that it was.
But you said the minister had no mandate or power to confirm such.
No, that was maybe a spell of the time.
So you are supporting the stance that the minister has power?
Yes, the minister had power to declare that Bakomaso area to
because of the GM.
Not because of the GM, but by reading Section 4 of the Village Land Act, which provides the procedure of declaring a village land to be a reserved land.
Okay. Look, I admire your opening speech. It was quite fiery. Okay? So I want to understand from the office of the Attorney General, were you consulted? Were you aware that this case was going on? I mean, the negotiations. Were you consulted in any way?
This is another defect to show that that particular action was done in contravention with the provision. Reading through Section 19 of the Office of the Attorney General Discharge of Duties Act, this particular contract needs to be engaged to engage the Attorney General. And also Article 12.
So you were not consulted?
Yes.
Okay. So by that you are further admitting the government violated or continued to violate its own internal laws and then places the blame on the plaintiffs?
Not making will be also trying to that have been provided under Section 4 of the Village Land Act.
Counsel, I am still very much perplexed. Can you give me the simple definition of what a defense team is supposed to do in court?
Is to defend the action of the is to defend the case for the defendant.
Okay, then why are you that in Simiswa Village Council deliberately entered a contract to, what should I say, to hurt the villagers and cause them distress while knowing that they had no power at all to do anything?
Reading through clause. it showed that this particular area that was taken to that particular proponent, that particular project, was having 3,300 kilometers square. However, reading through paragraph 18 of the material fact, it showed that the area that was under the Zimizwa, under the Zimizwa Village Council, was just 140 kilometers square. This showed that whatever action that was entered to grant the area in this particular project was in excess with the whatever action that was made by the first defendant was not in the power that was confined to do that. And as I have submitted that this particular area was under jurisdiction, the Zimizwa Wildlife Management exclusive right, granted exclusive right to Forest International Limited.
We can move further, taking into concern the interest of time.
Yes, thanks to that of the game reserve. Then that particular area of game reserve under paragraph 18 is section 8 of the Wildlife Management Act. In terms of brew of the Wildlife Management Act, in terms of brew carbon credit, authority is the Zolibanzi Valley Management Authority. I humbly submit.
Honorable judges, it may please you, my name is a pre-contractual agreement which is entered between the parties in anticipation that sometimes in the future, the NGO of Nigeria held that the nature of memorandum of understanding is that it is used as an authority for this memorandum of court.
Council, before you proceed, further.
Council, sorry, before you move forward, you have and in this case, the court held that it's not the title of the documents which gives the same.
Thank you for the question, Mr. Judge. It is our submission that the case which was stated by must have shown clearly in the memorandum of consent that they are intending for the memorandum of understanding to be bound up. But the memorandum of understanding then would have just entered into a main agreement or into a contract.
Yes, understanding. And they have asked this court to consider clause 15 dispute before the court of law. Don't you see that the parties intended to enforce their understanding or to enforce their agreement? So if you go on in line with the should consider the intentions of the parties. And if you go to clause 15, 1, 2 of the memorandum, it is explicitly clear that the parties have demonstrated that they indeed intend to enforce their rights. And the doctrine of stare decisions. But to see that you have gone decisions in the Court of Appeal.
First, I would like to submit on the nature of paragraph 15, sub 1, 2, which is the dispute resolution clause. Honorable judges, the purpose of the clause is often to manage the disagreements that may arise during the negotiation of the interpretation of the memorandum of understanding. Usually, it does not mean whenever a memorandum of understanding has a clause about a dispute resolution, then directly it means that the parties have intended the memorandum of understanding to be bound up. According to the case which was presented before this honorable court by the chiefs, if I may state the brief facts and try to elaborate on how the facts are distinguishable with the facts at hand. In the case of Wananchi, the parties had agreed to deliver goods. The plaintiff had agreed to deliver goods to the defendant. The goods were worth 1 million. The defendant was supposed to pay the whole amount, but he did not pay the amount. So the parties had agreed to enter into a memorandum of understanding so that they can have an agreement on how they are going to pay back the remaining sum. The issue before the Court of Appeal was whether that memorandum of understanding amounted to an enforceable document. And according to the nature of the facts, it is clear that the parties had intended for the memorandum of understanding to be bound upon them. But the facts at hand today are different because parties according to paragraph 5, sub 2, sub 1, sub 7, it clearly shows that they have put a direct clause which states that to ensure that the parties have an obligation to ensure all the required legal obligations are met before entering into a contractual agreement. So the fact of the use of monarchy is distinguishable with the present time, because here parties already have a clause in the memorandum of understanding stating that they will do all the legal requirements, but sometimes in the future they will enter into a main agreement.
So based on what you are saying, that means this MOU means nothing to both of you. And if I take you back to the facts or even to the other issues that you were addressing, you indicated that there was an agreement that was entered between the plaintiff and the defendants to implement the project. And you charged the registration fee. You imposed the taxes. You did all what you had agreed with both parties. To deliver, failure to deliver. Now you have an MOU here. You have to confer some rights to implement the project. So what is the difference from the facts that you are narrating and the facts that are before this particular court? And even the clause that you are referring, clause 15.1.2, if you read the wording of that clause, it indicating that if there is any dispute arising on the connection of this MOU, shall be submitted for determination to the court. So that enough doesn't signify.
As I stated, that it is our submission that a mere fact that parties have included a dispute resolution clause does not mean that the parties have intended for the memorandum of understanding to be binding upon them.
So let's put it this way. I help the court to understand. What should have the provision stated to indicate that they really wanted to go to court? And in other words, in the context of what we're dealing with, we're talking about billions of monies involved. So you're telling this bench, someone comes all the way from Europe, comes to invest here in Africa, a lot of monies, and then he doesn't care whether there will be any consequences, whether the monies will be lost. He really doesn't care. So for that reason, even when they said in case of any conflict will go to the court of law, it was just a declaration. Is that what you're saying?
What I'm saying is that it's not like the contractual agreement. That does not mean that sometimes in the future they would have failed to enter into a contract. And it was easy for the
Is there a provision in this memorandum of understanding that says after this, when we think we are okay, then we are going to create a future contract? Or did the obligations that were implemented were all based on the memorandum of understanding?
According to the nature of one amount of obligation of the parties was to comply with all legal requirements pending entering into contractual agreement. So the wording of this obligation clearly states that the parties had intended that, okay, now we will enter into the memorandum of understanding, but sometime in the future, then they will enter into main agreement, and it is our submission.
Wait, that provision does not say they will enter into a main agreement. It doesn't say so. If I'm not mistaken, you're misleading the bench. The provision says memorandum of understanding would make sense if they comply with the laws. And what are these laws? Getting necessary permits, having necessary authorizations. Isn't that what happened in this scenario?
With all due respect, if you allow me, I would like to quote the...
Please.
Okay. This paragraph states that to ensure all required legal...
Which paragraph example?
Paragraph 5, sub 1.
Paragraph 5 deals with what? Obligations?
Obligations of the parties.
Of the proponent.
Obligations of the parties. Okay, according to sub...
Which party?
7.
Which party of the two parties?
Obligation of both of the parties.
Just read it very well.
Okay. According to this paragraph, it states that
the opening words, what do they say?
in implementation of the MOU, the proponent have the following responsibilities.
So we are dealing with the proponent. What is one of his responsibilities?
One of his responsibilities was to ensure that all legal requirements are met before entering into the contractual agreement. As here, parties, they clearly show that this was just a memorandum of understanding, was just a contractual agreement, and that sometimes in the future, after fulfilling,
Well, the part sometimes in the future. Where do you get that from?
The laws, the clause states that to ensure all legal obligations are met before. The clause used the word before. This means that they enter into, before entering into main agreement, they are now supposed to adhere to all the legal requirements, which includes the asking of the permit and everything.
Thank you.
Okay. Hence, it is a humble submission that the memorandum of understanding is not enforceable because parties have never intended for the memorandum of understanding to be enforceable. I would also want to stress the issue about clause 15 sub 1 2 by stating the issue of after management AG, this is Atalaya Mining PLC, the case of 2017, decided by the High Court of England. The fact of this case was that the plaintiff and the defendant entered into an agreement involving the financial development of the mine. They signed a memorandum of understanding and outlined a dispute resolution clause. The issue before the court was whether the memorandum was legally binding given the presence of a dispute resolution. The High Court of England held that the MOU was not legally binding just because parties had a dispute resolution. But the purpose is that parties will seek to resolve disagreements which may arise during the negotiation stage.
Between the decision in England, okay, High Court in England, and the decision of the courts of record in Tanzania, what is the most binding decision of the two?
The most binding is the Court of Tanzania.
According to the decision of the Court of Tanzania, can a memorandum of understanding amount to a contractual obligation that is binding before the parties?
Honorable judges, would like to submit that among many sources of law which are binding before this honorable court is not only the decision which are made within the jurisdiction, but also according to section 2, sub 3 of YALA, even the decisions which are made under the common law, customary law, can also be binding. It has
fair enough. Trust me, I understand the argument. According to the argument you're proposing, do you go to common law if we have sufficient authority in Tanzania that is applicable in a situation, like in this case?
I would want to submit on a case which was held here in our jurisdiction to emphasize on the point that the memorandum of understanding is not enforceable.
Okay, please give that.
According to the case of the Hadidia Kalumanga, Mrs. B. Paris Miso, the Court of Appeal of Tanzania also held that the mere fact that there is a dispute resolution clause within the memorandum of understanding does not always mean that the parties had intended the memorandum of understanding to be binding upon them. But
between that decision and the Mwananchi case, which is the latest?
so if I insist with my co-counsel to say,
Please do, because that is an important issue.
Honorable judges, I left the matter to my fellow counsel, and once he resolves the matter, I will address this court. Okay. Now, I will go to address this honorable court about the issue 3.
Counsel, you have remained with 3 minutes, so you should be able to finish your last issue as quickly as possible.
Okay. Honorable judges, it is our submission that the charging of 18% VAT during the registration phase was valid. And this is because, according to according to carbon credits regulations, provide, according to regulation 26 of the environmental management control and management of carbon credit regulation, under section 26A, provide that the project proponents are supposed to pay the registration fees. Okay. Adding together with that section, I would like to address the court on the second schedule of this regulation. According to the second schedule, it describes all the necessary payments which are supposed to be charged during the registration fees, which includes the 1% of the expected carbon which will be generated from the project. Honorable judges, we discussed this point together with section 15 of the Value Added Tax Act, which provide that the value added tax imposed on a taxable supply shall become payable at the area of the time when the consideration of supply is received in full or in part. Honorable judges, it is our submission that the payment of 1%, which is prescribed under the second schedule, is part payment. Why am I saying this? I'm saying this because the 1% which is payable is the estimated value or the estimated number of the carbon that the proponent will get from the project. And hence, this benefits them and it falls under the requirement of section 15 as a part payment. And hence, according to this section, it was proper for the authority to charge 18% over the registration fee.
Counsel, how do you respond to the plaintiff's arguments that these fees are not a taxable supply?
Honorable judges, according to section 2 of the Value Added Tax Act, defines what amounts to a service. And if you go to paragraph E of the definition of service, it states that a service is an issue, a transfer, a surrender of a license, permit, certificate, concession, or authorization. According to the case at hand, the plaintiffs were seeking authorization. The registration process is a service itself because now without the authority, they wouldn't come within our jurisdiction to invest in the carbon credit. And hence, the services that were provided falls within the definition of the service as provided under sub E.
Council, we should go to the prayer because the time is over.
Okay. Honorable judges, we would like to state our prayers and submit as follows. The declaration that Ecoforest Limited lacks locus standi to institute the matter. A declaration that a memorandum of understanding between Ecoforest International Limited and Indonesia Village Council is not enforceable under the laws of Zimbabwe Republic. The declaration that the charging of 18% of the value added tax was valid. A declaration that the grant of exclusive right to Ecoforest International violates the legal permanent sovereignty laws. A declaration that the grant of exclusive right to Locomoso was invalid. And we pray that for the order that the court dismiss the plaintiff's case with cost and any further reliefs that the Honorable Court may be fit to grant.
Yes, Councillor Value, and your time is over, but we reserve only questions between the case of Mwananchi and that of Mwananchi case and Mwananchi. We were interested to know the most recent, and we have one question to that effect.
Okay. The Mwananchi case is the case of 2014, and the case that I stated is the case of 2023. And the most recent decision is the one which is binding before this federal court.
When the decisions of the apex courts are in conflict to each other, because both the decisions of the Court of Appeal, when they're in conflict, what are the legal positions?
The legal position is that the most recent, please give me 30 seconds.
You get it from the law, you get it from the court pronouncements, or what?
Just
generally, where do you get that position? From the legal statutes or from the court pronouncements?
We get it from the court pronouncements.
Thank you. Just Yes, counsel, for the plaintiff, before you stand up, you consume your entire time, consume the 1 hour. And do you have rebuttals?
Honorable Judge, would like to ask the court's permission to just give us 3 minutes and we'll brief on rebuttals.
3 minutes? Granted.
Much obliged. Honorable Judges, we have heard the arguments of our opposing counsel, but to set the records clear, our client is not a planner or a colonizer, as claimed by the opposing counsel, but this attitude arising from these government agents has clearly violated the investors' rights of our client. Honorable Judge, our client is not a colonizer. But also, Honorable Judges, since the opposing counsel has relied on the contradictory statement 7 of the Memorandum of Understanding, would like this clause to be enforced against him as per contract-preferential rule. But also, the Lord Council has ignored the provision of Section 202 of the Environmental Management Act. But also, the opposing counsel has conceded that our client obtained lawful access to those resources, meaning that it abided to the principle of permanent sovereignty. The opposing counsel has clearly provided that it was the fault of the first defendant and not our client who violated the principle of permanent sovereignty. But also, Honorable Judges, with due consideration, I will emphasize the opposing counsel to go through Section 147 of the Local Government District Authorities Act, which provides executive power to the village council. The authority that was given by the village council was very valuable to our client. But also, the opposing counsel has ignored the procedures to be followed to transfer the village land, and having said so, the game reserve falls under the jurisdiction of the Mutimuza village. But also, Honorable Judge would like to consider the plaintiff to go through the case of Akopar that was decided by the Court of Appeal when it comes to bindingness of foreign precedents in this court, and we submit that all foreign precedents that did not suffice the test established by Akopar's case does not bind this honorable court, and that is our humble rebuttals.
Before you leave the podium, set allegations in the suit. What the law of the plaintiff lawyer in that circumstance?
When the defendant has admitted the allegations.
So the plaintiff lawyer has no any role, and this is left to the bench, right?
Yeah, because you have one to decide.
Okay, thank you very much. So you are embracing the equality of arm doctrine. You also agree.
The plaintiff considered in their preliminary argument that the Management Act is misconception for this honorable court, and this is not regarding to the first issue that this court ruled that the plaintiff has no locus standi to bring this case before this honorable court. Regarding to the issue number 2, the contractual agreements are not enforceable. They are meant to facilitate the main argument. I draw this court attention to the issue that facilitated later into entering into a specific contract. This particular Memorandum of Understanding has not taken to the Parliament for ratification, as the requirement under Section 12 of the Act was submitted. Regarding the issue number 4 on the principle of sovereignty of our natural resources, the cited provision of law doesn't confer the village council authority to deal with the reserved land. This has been restricted under Section 14 of the Village Land Act, which restricts the village council to transfer or to deal with any land that is provided under that particular act. And also, I would like to refer this court's attention to the issue of the case of Commission for Human Rights of Kenya versus Commission for Human Rights versus Kenya. This is a case. In this particular case, the Human Rights Court decided the issue of the grant of Ogeki people rights, which were in contravention with the principle of permanent sovereignty over natural resources and the right of the indigenous people. And it is our submission that this court find that the argument by the plaintiff it's the one submission that this court dismissed the suit in its entirety.
Yes, Councillor. We want to get to a general understanding and concept in one area. You have tried to. It seems that there was a question of human rights, the question of protection of human rights. So I want
constituted into the human rights, into the panel of judge by following the rules and the legislation.
No, when the issue arises in the due course of the proceedings, yes, like the 1 year, who are the would like to invite my fellow judges.
So that I don't cause anyone to cry very hard, and I appreciate everything. You appearing like you are laughing at the judges, you know. The arguments are you planned, but if you can work on that, I believe.
Good afternoon. I'd like to say congratulations. Lots of opportunities, I believe. Yesterday I was informed as a gesture, the ones I've met. Make sure you connect with people in this room, in this area. Get yourself something somewhere so that when you're done with where you're at, you can move further than where you are. But other than that, good job, and I hope to see you soon.
I just have to congratulate both of you, both teams, for the efforts that you have made. So I understand what it takes to moot, or to the struggle, the preparations, until you make it here, to the final. Even those who are sitting there, even if you didn't make it to the final, I use this chance, probably will not have this chance again. So to congratulate all the team that participated in this moot. So you're doing the right thing. I'm sure each one of you had a chance to learn. You have learned in the process. So for those who made it to the final, I put much emphasis on my congratulations, because you deserve more congratulations, because you can see the fruits of your efforts. So I just want to say that each one of you did well. You deserve a bit of a time to breathe out. So you hear good things only now, until when the truth comes out. So for now, each one of you did a wonderful job, and later on you will have the winner. But I just have to encourage you to keep on doing this. If you think that you didn't do well somewhere, so it's a step to learn. So just add more effort, and later on you will see the fruits of what you are doing. So I just want to encourage you to continue to learn and to do even much better. So that's all. Thank you.
Congratulations to both of the teams. I don't think there is a lot to say that has not already been said with regards to the good things. Just a few additional comments that I'm going to make. I am also a mooter. I've been in the seats you're sitting, and I know the pressure and the stress that standing on that podium comes with when these people here are grilling you with questions. Some things you've not prepared for, some things you've prepared for, but you all handled that very well, so you deserve to congratulate yourselves for that. But just a few tips for the finalists and for anyone else who's going to moot in the future. What I can say is, one trick that is very useful, you should listen to the judges. Listen to the judges when they're asking you questions, but one trick that they don't tell you is that you should listen to the judges as they're asking your opponent's questions, because that is where you'll find the holes in their case. Listen to the judges, bullet in those holes. Is what they're saying to Swahili. Also, one other thing that I would say in order for addressing your arguments, bullet your arguments first. If you're going to cite a case, I've seen this problem yesterday and I'm seeing it today. If you're going to start with Lujuna Shuli Balonzi, or you're going to start with any case law, clearly provide all of the legal principles, and then you start to say, these facts apply, I'm applying these facts to this principle. That way you allow the bench to follow your whole argument. Sometimes as you're in your first principle, the bench is already questioning about the third one, and that way you might lose track of your arguments. It will really help you to make sure that the bench follower understands that I'm going to build this argument down the line, and then at the same time, you're also not allowing yourself to lose track of what you're going to present. That will help you respond and manage your questions better. But overall, you did your best and you always managed to stay on track. Also, manage your time as mooters. It's hard. This time, there was no one telling you that maybe the allotted time has finished. So if you had split each amongst each other, 20 minutes, 30 minutes, if you're not watching your clock and your teammate was not reminding you that your time is up, no one was telling you. So it might not happen in a real court, but sometime you might be in a meeting or you might be somewhere where you need to watch your own time. Watch your own time, because when you consume more than the budgeted time, you don't allow your teammate to show their best selves. because we're judging the team. If your teammate cannot show their better half, your team is your better half in this case. Your teammate is your better half. You don't allow your better half to also show their answers and show the quality of their arguments. You don't really allow your team the room to accumulate as many marks as you could. So always be willing to manage your time. I've said this to some other teams that it's not about telling us everything you've prepared to tell us, but it's about telling us a few good arguments and then saying, okay, the rest I know are written memorandums, we can incorporate them as arguments. I'm going to sit, my co-counsel will address the rest of the issues. It's a quality process. Don't worry about telling us everything you're prepared for. But also the last thing would be, do not admit. It's good to be honest and be a lawyer who is honest, and it's a quality that you want to build as a lawyer, but also you need to also learn to be slippery. You should not say, I admit. You should learn to be a bit slippery. Do not, even if you're in the wrong, you want to use the correct professional words. I wouldn't say political, but I would say professional words to use to communicate that, yes, there might be somewhere here that I might be tied up, but I'm not admitting anything. Because at the end of the day, leave that to the judges. It's not your role to commit. So I'm just going to say that you've all done a very good job. You've been put in the tightest of spots. You've had a lot of pressure. You deserve congratulations. And in the eyes of these judges, I believe, I speak for all of them, you are all winners here today.
Maybe one comment to the most youngest practitioner, Mr. Mzava. I'm told that you're the most youngest practitioner in this competition. As you are a first year law student. Yeah, I was basically impressed by your presentations. But the one thing you should note that you should not leave matters for the court to decide. Because I prompted you that if the other party admits some of the allegations, as a plaintiff lawyer, what is your role? So I expected to say that if the defendant admits some of the allegations, you will move the court to enter judgment on admission. And that is on 12 of the CPC. So the court cannot by itself move, it must be moved by the parties. So that's I think you keep learning. But generally, the presentation was nice. And I'm so much limited to speak so many issues here. Because we retire to compose the judgment, you will see our deliberations in our judgments. Yeah, for that end, we adjourn the court and judgment on notice.
Matokeo ya mshindi na vitu vingine vyote hayatatangazwa hapa. Badala
yake wanafunzi, usafiri unafika hapo chini muda sio mrefu kwa ajili ya kuwachukua kuelekea Serena Hotel. Na wageni pia ambao mmefika hapa siku ya leo, mnakaribishwa Serena Hotel kuanzia